I define really a catastrophic injury as somebody that's had a severe spinal cord injury, amputation, a traumatic brain injury, death case, generally situations where from the injury it's doubtful that the person is going to be able to work again and will need a significant amount of medical treatment for the rest of their life. Why we use AMEs in the system is I'm looking for a doctor that I've seen their reporting from before that I know will be fair to the client.
I'm here to accurately represent your injuries in an accurate way and answer the question of the parties. And hopefully that resonates well with the industry. I mean, it doesn't take very long before they discover it and they feel you're biased and you're not going to be used. And there's a lot of people who fall into that category.
Some people may just take a deposition to try to change the doctor's mind on a certain issue. That's harder because you're never going to win as an attorney generally arguing medicine with a doctor. You may win facts of the case, you may win law, you may, what records did you review, but generally if it's a medical issue, we're not trained as attorneys to really attack a doctor's finding on that issue.
Having prior injury doesn't negate that he is injured again. It just indicates that there was a prior injuries.
Nobody's perfect, but it's somebody that's going to help us resolve a dispute, close a case, and something that's going to be substantial medical evidence if the case ends up at trial. Apportionment is a medical issue to be determined by medical doctors. So at the end of the day, we need a medical doctor to comment on apportionment.
My understanding is that an AME report, recommendations for future medical, are barely ever disputed by the insurance. Is that correct? Good morning. I'm Paul Wakim. I'm an orthopedic surgeon in Southern California, and I do mostly AMEs and QMEs in orthopedics. And with me is Dane Gillaim.
Hi, I'm Dane Gillaim. I'm a partner at Bentley and Moore, and my firm primarily handles catastrophic workers' compensation and personal injury cases.
And what do you mean by catastrophic? What level are this firm associated with?
Sure. So I define really a catastrophic injury as somebody that's had a severe spinal cord injury, amputation, a traumatic brain injury, death case, generally situations where from the injury it's doubtful that the person is going to be able to work again and will need a significant amount of medical treatment for the rest of their life.
Right. Dane, what makes you, or what time do you ask for a QME or AME? What's your preference here? And why do you do that? And when after treatment has started or ceased, do you ask for an AME or QME?
Sure. I think really any time that there's a dispute, which could be any time in the case, if the case is denied, then I'm going to need a AME or QME kind of out of the gate to resolve the medical dispute. Obviously, if the person is in some level of inpatient care, I may wait until they're out of inpatient care to get an AME or QME. So I think just everything just depends on the facts of the case and how severely injured they are and what medical treatment that they need prior to getting to permanent and stationary status.
Great. AME is usually chosen, and we get paid more. We get paid 25% more than a QME. We get chosen for certain reasons. And hopefully it's knowledge of the system, knowledge how to conduct an examination, and fairness to all parties involved. What makes you choose an AME over a QME? What is more likely to resolve the dispute quickly for you than otherwise?
Sure, that's a great question. I think why we use AMEs in the system is I'm looking for a doctor that I've seen their reporting from before that I know will be fair to the client. I know that will review all the medical records, whether they're good or bad for my client. We'll review all the deposition transcripts. We'll review all the evidence and then understands the concepts and the cases, and we'll call it like they see it, whether that's good or bad for a party. That's what we want. We want somebody to look at the case and forensically tell us what the level of disability is and what disputes that they can resolve. So I think that's why we use an AME generally over a QME, where you might not have that familiarity with the physician. It could be somebody brand new who just got their license, last year. It could be somebody that's been doing it a certain way for a long time and maybe still, despite doing it for 30 years, doesn't understand the law or maybe has a biased view one way or another, either pro applicant or pro defense.
Speaking of bias, I make it a point whenever I'm seeing an AME or QME for that matter, is I tell them I'm here. I was asked to evaluate you and accurately reflect on your injury. I'm here to accurately represent your injuries in an accurate way and answer the question of the parties. And hopefully that resonates well with the industry, is that accurate representation helps both sides. They get a good understanding. But when you have bias to one side or the other, I mean, it doesn't take very long before they discover it and they feel you're biased and you're not going to be used. And there's a lot of people who fall into that category. Do you agree with that?
Yeah, I think that's fair and probably could be from just lack of training,
Yeah.
right? Again, I think, the best thing why you have an AME is just to call it like you see it. Sometimes that's going to be the injured worker has 100% disability. Sometimes it means they're going to have 5% disability. Sometimes it means there could be no injury, but whatever it is, I want the AME to come in with an open mind, read all the medical evidence, spend a lot of time. We didn't talk about earlier why I generally like AMEs. They generally spend more time with the injured worker. I think per the CCRs in the labor code, I think it needs to be at least 20 minutes or something like that. But for what I've seen in some AMEs is they'll spend an hour
Yeah.
with the person taking their history. And it's not just 10 minutes or somebody, their caseworker talks to them and the doctor just comes in and does the physical examination. So I think that's what we're all looking for, a more thorough report that can resolve a dispute, get the case resolved, and it's create a win-win for everybody.
Yeah. When I teach the process to younger doctors who are recently entering the system, I tell them you're going to get well paid to do a good job. So do a good job from the beginning, represent them accurately. I tell them, depositions occasionally occur, but really don't reflect too well on the fact that you had a complete report. If you had it, more likely they won't ask for a deposition. Is that your understanding, you think, or when do you ask for a deposition?
I may be a little different in this regard. I may take a doctor's deposition to strengthen their findings. There is a couple cases that require the doctor to have more analysis because whole person impairment, that's my burden as the injured worker. The
Sure.
same thing as AOE, COE, or a part of body. So if I think the doctor has addressed those, but maybe doesn't have the level of analysis that a judge would like for substantial medical evidence, I may take the doctor's deposition, just get them to explain the how and the why of why they made that. That way, if the case is still disputed at trial, I have a better chance of prevailing because it's all been well documented with the analysis that a court likes. Some people may just take a deposition to try to change the doctor's mind on a certain issue. That's harder because you're never going to win as an attorney generally arguing medicine with a doctor. You may win facts of the case, you may win law, what records did you review, but generally, if it's a medical issue, we're not trained as attorneys to really attack a doctor's finding on that issue. Hence why we go to a AME is to resolve a medical issue with the case.
Correct. I want to ask you that I have always told, my students in medicine and orthopedics that, you're chosen in effect to resolve dispute on medical issues. You're not here to show them how good a doctor you are, how great a doctor you are. You're just accurate representation. Do you feel, as an applicant counsel of a very well-known firm in Southern California, do you feel that you can take a QME report and resolve a case as quickly as you would with an AME? Or is it always you pit the QME against a PTP report and you see which one is more reasonable? Or what is your on the speed or expediency of resolving disputes in front of the trier of facts, the judge? Which one is your preference?
Sure. Yeah, I generally prefer AMEs because I can probably get them in faster. they understand the concepts, I can probably get a report faster. If there is a need for diagnostic studies on a medical legal issue, generally most of the AMEs will do that properly and get the diagnostic studies, whereas a QME, sometimes it disappears into a black hole and you never know, it might take a little bit longer to get all those diagnostic, studies done. But generally, in my experience, with an AME, I think that leads to quicker resolution of certain issues because they understand the concepts and there's less, holes in their reporting that I need to fill in, as the applicant's attorney.
I like that. I really do, because that is really, really accurate. And I feel comfortable in saying that when I do an AME report, I know it's my responsibility to resolve such disputes you're talking about on medical issues. And it's my job also is to represent the injuries accurately. And I don't hesitate to question the applicant on prior injuries. And what we should tell really the public, having prior injury doesn't negate that he is injured again. It just indicates that there was a prior injuries. So it's an educational process that the AME have gained over time. Over time. Let me ask you, what makes a good QME or AME report in your mind?
Sure. A good medical legal report is a doctor that has reviewed all the records, a doctor that has spent time with the injured worker more than the minimum, a doctor that understands the cases and the concepts, a doctor that can also articulate, why, and also a doctor that just resolves the dispute and calls it like they see it. Also, I think a doctor maybe has an open mind at a deposition. I know sometimes doctors, you don't like to be questioned as to, some of your finding. You may attack that personally, but maybe with an open mind that, hey, maybe they made a mistake. Maybe they missed a record, or maybe they forgot to address an issue in the party's advocacy letter. That all happens. Nobody's perfect, but it's somebody that's going to help us resolve a dispute, close a case, and something that's going to be substantial medical evidence if the case ends up at trial. I think that's what a good QME or AME, would do in a case.
I have to admit to you that I do my reports personally and I interview the patient personally. My history is prepared for me by a historian. Records are summarized by my historian, and we indicate that. By the way, the new law indicates you should say who summarized your records for you. You're supposed to review them and have them available for further review if needed. But we summarize the records, and I dictate my own. But occasionally, after I review the records I've reviewed, and I would be doing my discussion, and I would say words that are interpreted differently by the dragon that I use for my dictations, and it turns out to be incorrect. And then at deposition, the one of the counsel or the other asked me, "Do you really meant to say that? Or it's an error that you said that, or this finding is an error?" And I find it easy for me to tell them, you know what? Yes, I made a mistake here. And they're not going to hang you for making a mistake. They're just going to go by, okay, let's correct it. What is the accurate response? And you do it. Do you find that the reports you see from QMEs or AMEs have a certain level of inaccuracies or incorrect statements?
I think it just depends on who it is, right? Generally, most of the doctors I've used that I think can write a report that's substantial medical evidence, I don't see too many, glaring ones. Again, it's akin to taking a deposition of an injured worker. Maybe those address is wrong. Clearly, if
Yeah,
it's a minor change, it's
minor
not really
change.
going to be
It's
an
the
issue.
content that you
Yeah,
look for, the
exactly.
impairment rating, the apportionment,
Yeah.
future medical. How much of our future medical recommendations passes through the insurance and they approve it? How much of it do they send it out to be verified for further care?
Sure, that's a great question. So if the injured worker is permanent and stationary, the future medical care recommendations that you have as a AME or QME kind of just help the parties to negotiate the value of the case. Obviously, if there's a lot of future medical care, moves it up one. If they don't need any future medical care, then that makes it, a much smaller case. But, AMEs and QMEs can no longer resolve medical treatment disputes. That's all from the primary treating physician who does a request for authorization, then utilization review, and then IMR. So if the injured worker is not permanent and stationary, your report still can go to doctors on that issue, but it's not going to be as dispositive as the RFA, UR, IMR process.
My understanding is that an AME report recommendations for future medical are barely ever disputed by the insurance. Is that correct?
I mean, people go to AMEs to resolve disputes. So
Yeah.
if you've been chosen as an AME, that means both parties
Agreed on you
and will be, think that you're a fair doctor to resolve disputes. So generally speaking, I don't really view that as a big issue, more as impairment or work restrictions or vigil or Alvarez that
Yeah.
are more contested aspects of medical
Yeah.
legal reporting.
Why Pacifica Orthopedics? Pacifica Orthopedics, we have trained physicians who have been certified as QMEs, who do QMEs in orthopedics as well as AMEs in orthopedics. And they do it at multiple locations. Our main hub for taking the appointments is at 714-841-5333. That's in Huntington Beach. But we have offices also available in Los Angeles, Long Beach, Huntington Beach, Anaheim, Garden Grove area, Santa Ana, and Riverside. The orthopedic surgeons at Pacifica Orthopedics know that we have a commitment that we harp on constantly, is to be accurate. You are to represent the injured worker accurately. That means don't give them too much more or don't give them too much less. Just whatever the injury is, report on that, because all parties will be happy with you afterwards. They know you're credible. They know you're expedient. Usually our reports are generated within 7 days after we see the patient or before. So if there is an injured worker and there is disputes regarding medical issues for any reason, whether it's treatment, whether it's impairment rating, whether it's apportionment or issues of causation, you should consider Pacifica Orthopedics and our doctors, Dr. Emil Wakim, Dr. Paul Wakim, myself, or Dr. Ram Mudian, or Dr. Robert Ahern. They are expedient, they're accurate, they're honest, and they will represent your injuries accurately. Great, you mentioned Vigil. Is Vigil represented more easily than Kite nowadays?
Well, I think because there's more precedent of it because it's a en banc decision where it has to be followed by all the
Is
courts.
Kite not en banc? Was it a 3-panel or what?
Kite was just a panel decision.
Panel of 3.
Yeah, en banc means all
7.
the judges. Yes.
Yeah, 7 of them.
Man, you have a good understanding of all the judges and systems here.
Yes, I have been here for a couple of years.
But yes, Vigil upholds Kite and gives a little bit more of the law on what is needed for a proper Kite or additive case.
But Vigil is in effect different from the ADL kind of representation. One of them, there's an overlap. One of them really necessarily not an overlap, but it's worse. How would you explain that?
Yeah, so with Vigil, we're talking about adding impairments.
Yes.
And in the
Same with Kite.
Yeah, correct. Same with Kite. So we have to start with the CVC chart. CVC chart is a rebuttable presumption. So generally speaking, impairments are to be combined per the AMA guides and PDRS. Kite and Vigil allow the doctor to add impairments in certain circumstances. We have kind of 2 examples of it, and before that, you have to document the ADLs. So ADLs are more important to be documented, I think, now more than ever. So we have to document the injured worker's ADLs. Then for the impairments that are to be added, you take each impairment and determine what the ADLs are for those impairments. If there is minimal overlap in those 2 impairments, let's say a upper extremity and a lower extremity, it's probably not going to be much overlap in way of activities of daily living because those are 2 different kind of functioning parts of the body. There's going to be no overlap there, and that can be a way a doctor can add the impairments. The other way, and I think this resonates a little bit better, I think, with the medical community and the legal community, I think, is the synergistic impact. So if you have a double extremity injury that makes it, they don't have a good extremity to ambulate on, right? 2 legs, 2 hips. It was 2 hips in the classic kite case. Then their ADLs are impacted more because both body parts are at issue. So, for example, with the hips, sitting, standing, bending over, lifting, squatting are going to be more difficult with somebody with 2 bad hips than with 1 bad hip, essentially. But again, it all comes down to the doctor's analysis in those cases that will allow it. And it's not to be used on every case, but in certain circumstances where the doctor believes it's appropriate, especially a bigger injury, then I think it's going to have more weight with the court.
Can we, Dane, can we emphasize to the QME or AME the point that they should mention what ADLs are being affected by each injured part? Would you agree with that?
Yes, I think that will make it easier to address all the issues of the case, including impairment, if the ADLs are more documented thoroughly by the doctor.
Well, when do you ask for a supplemental report?
Sure. I will ask for a supplemental report when I need some minor clarification from the doctor that doesn't necessarily have to do where I have to take their deposition. It could be, hey, doctor, you saw in my letter, I asked you to address this concept or this question. I didn't see that you did it. Can you address it now in a report and provide the necessary analysis? I need a deposition if it's going to be a much longer discussion and I need more analysis on the issue that I think is more probative in a deposition.
You know, I know your firm and I know you to really be very well prepared. In any case, I personally get from you guys, everything is well prepared, everything. But sometimes I see a case being sent to me really with hardly any paperwork, as if they're asking the QME or AME to do the case for them, or to prepare the case for them, or to advocate for them. Can we emphasize the responsibility on the applicant and what is the responsibility of defense in the QME, AME issues?
Yeah, I think you're doing everybody a disservice if you're sending the records late, if you're sending a generic letter to the doctor, essentially, hey, you figure this case out for me. It's not important enough for me. What I think most of maybe the medical community doesn't understand, when I give lectures to new QMEs or people taking the test, I don't think they really understand how important their role is in the system. A QME AME is generally more important than trial. It's because it's supposed to resolve a lot of issues. So with that said, you should do a good job, and we try, and I see some good defense letters out there too, on let's make sure we get the doctor everything he needs at least a week before the evaluation. We don't want anything last minute. And then what do you want the doctor to address? Is there a body part dispute? Is there a TD dispute? Is there a whole person impairment dispute? What is his role in the case? If you do something generic and you leave it to him to figure out, there's going to be a lot more holes for you to fill in later. And that's just going to result in more delays and more unnecessary expenses in the case. So well-prepared, detailed letters, I think, help everybody, applicant and defense, in our system.
Very good. Whenever I'm speaking like in front of a group of attorneys, I tell them, we're there as physicians, but when you see templated requests that are generic, really we consider, hey, our report's going to be complete. But when I see a bullet point question from your firm or from anybody else's firm, I realize that, hey, that's an important issue I need to address. So I recommend to the applicant counsels who need to prove their case is to ask us questions that are targeting the specific points they need to know. And similarly, on the defense side, hey, ask us, what do you need to know? What do you need to know about apportionment? Knowing full and well that they are concerned about apportionment and stuff like that. So I'm glad you really emphasized that point. Thank you very much. We discussed catastrophic cases. Who do you think are more capable of addressing the issues of catastrophic illness that may result in some cases in lifetime pensions? Is it a PTP who doesn't do QMEs, or the QME who just did it, or an AME? And who do you trust in the catastrophic cases? And how do you get them to reach the pension, life pension that sometimes they need or deserve.
Sure, or if they're, 100% disabled, obviously, primarily it's just a doctor that I know is going to call it like you see it. If, most of the AMEs that I work with have that reputation, that's not to say a QME can't do it. Maybe it's a QME who I've worked with previously who I find to be fair, or maybe it's the treater I find to be fair. But you have to remember also when you go to court, a judge, if they're going to look at an AME, it's more likely to be followed than not, per the Powers decision. And an AME obviously has, more weight than a QME report does. It also has more weight than a treating report is. But generally speaking, if an AME or a doctor that calls it like they see it on a catastrophic case and the facts are there on the case, then I think it will have hopefully a positive outcome for everybody involved.
When we question our patients on many of the activities they cannot do, we do question them also about psychological. We question them about sexual, and we understood from the beginning that as per SB 899, that those are really not areas that you can add impairments or combine them with. Are these still issues that you can consider for impairment purposes?
Yes, it's 863, I think was the modification.
That's 2013.
Correct. Yeah. So
comment on.
Yeah, you can. You can get a psych impairment on a case if it's called a straight psych case, where it's the result of harassment or they witnessed a violent act. You can also get psych on cases that have been legally defined as a catastrophic injury. And then you can also get psych on cases where the injury itself creates a violent act. So those are the cases that allow a psych to be involved in the case sometimes when it's a compensable consequence of an orthopedic injury. Sometimes you could have a direct psych case where the injured worker's in a bad accident, they have a traumatic brain injury, and the psych issues are coming from the brain injury. That's not a consequence of an injury. That's more direct. Sexual dysfunction is out on cases that are compensable consequences of orthopedic injury. However, if it's a direct injury to that area, or you have a cauda equina type situation where it's a nerve injury that's causing that, that's not going to be a compensable consequence. That's going to be a direct injury. So think of the more catastrophic injuries involved. Those generally lead themselves to having those additions that were eliminated by 863.
Some of the distress on opposite attorneys that are not here now on the defense side is when they see multiple QMEs. Initially, when SB 899 came about, it was one QME and he could ask for consults from others. They come to him and he incorporates it in a report. The QME was one QME. Now we see cases that have more than one QME, and sometimes some people, I'm not kidding you, almost in tears saying, this guy has 9 QMEs. So when do you ask for additional QME? What's really fair in the system, in your opinion?
Sure. If they have a documented need to be evaluated by another physician in another specialty, I think that's appropriate, right? So if we look at a catastrophic injury, let's say a failed spinal cord injury, right? We have the ortho, which would of course address, the back and then the gait, but they may need, if there's a neurogenic bladder or if there's a neurogenic bowel, they may need to bring in other doctors to address those ratings, per the AMA guides. If there's a severe psychiatric, reaction to a catastrophic case and it's documented, that's appropriate. I think where this got all kind of crazy in a way and led to abuse was people just pleading 10 different body parts on a case without any evidence, and then tried to use that as some sort of quasi-extortion attempt to the insurance company to pay more on cases. Because, we should never really, and I say this as an applicant's attorney, we never really should have a case where the med legal costs are more than what they're actually spending on the case.
Yeah.
That just sounds crazy to me.
No, yeah, I understand that. Believe me. And some of them say, you know what, we can settle this case more than the impairment values. So we settle it without doing that.
Sure.
And that,
So yeah, so as long as it's documented and there's those disputes to resolve with other specialties, right? It could be a disputed body part, but that's really the only way that we can resolve any type of dispute is using a medical legal.
as you must say that your firm has never really, in my opinion, abused the process from the point of view of requesting multiple QMEs when you needed one or two, maybe, or three, or whatever the case may be.
Yeah. And another way I could sometimes do it for the defense also is maybe you just recommend a consult, not a med legal.
Consult.
I
yes.
can start there, and if either party doesn't like the consult, we can object to that, and that's another gateway to get an additional panel.
What is the value now? We do know, right, that vocational rehab is not something now that you can award, basically. There is a certain amount you can give them in parallel to the amount of impairment. What is the vocational expert now can contribute to the process?
Sure. I think we're probably talking about two things. I think back in the day, they got vocational retraining, and now it's a supplemental job displacement voucher where the injured worker gets kind of a $6,000 coupon, and they can use that for education.
Is it only one coupon, or does it go up and down according to the impairment
Now
value?
that changed, I think, in 863. So it's just one coupon up to 6,000 where they can get some type of job retraining. And that's if they can't return to work, they get the voucher, and then they get 5,000 from the state. A vocational expert is used now on cases that are larger where you assign work restrictions that are significant if it's warranted, and that the vocational expert will then review those restrictions and determine, based on these restrictions, can the injured worker compete in the open labor market, or could they be retrained and do something else? That's what vocational experts do now.
And how does it benefit having a vocational expert involved? How does it benefit the injured worker from the point of view of award or retraining, or what is your opinion on that?
Sure. I think a vocational expert can benefit the injured worker by potentially finding them 100% disabled if those conclusions are they cannot be retrained to do anything else, and then they cannot compete in the open labor market. That report can also go to a medical legal. The medical legal could agree with it, disagree with it, or also use that vocational report to provide a alternative rating per Alvarez-Guzman if they've seen, hey, not really many jobs that this injured worker can do. I think a higher rating should be justified in that case, but it's a rare circumstance.
Dane, are you asking for the work restrictions for that specific job he was at when he was injured, or are you asking for work restrictions that's universal, that the person cannot do any work at all? Where are those work restrictions important?
Sure. It could be, if it's a smaller case and you think they can return to work, then obviously the QME is going to determine can they go back to that job. If it's a case that, is a higher exposure one, again, I want the QME, AME, PTP to provide whatever the accurate restrictions are. It may preclude them from the open labor market. It may not, but that's really the job of a vocational expert, is to look at your restrictions and make those conclusions. So I think you have to, as a forensic medical legal examiner, can they go back to their other job with some modifications, and what's their general work restrictions altogether?
How does that affect the impairment value and the award?
If the vocational expert determines they cannot compete in the open labor market or be retrained vocationally, it is a 100% permanent total disability case.
That's if you cannot in any job market, correct?
Compete in the open labor market is the term.
Okay. One last question that we have discussed, me and you, in talks we have given, is the Nunez case. Is that still applicable? Can vocational rehab comment on apportionment?
A vocational rehabilitation expert cannot provide their own alternative apportionment analysis. They are free to say if they want to agree or disagree with Dr. Wakim's apportionment opinions. However, apportionment is a medical issue to be determined by medical doctors. So at the end of the day, we need a medical doctor to comment on apportionment.
Very good. I'm grateful to have you here with me. You're such a breath of fresh air, really, and really very knowledgeable and fair, and really fair. I must say that you represent your firm very well. Thank you for being here, Dane.
Thank you, Dr. Wakim. Pleasure
Thank
for
you.
having me today.
Thank you, sir. I'm Paul Wakim. I'm an orthopedic surgeon in the Southern California area. We have multiple offices, and we specialize in treatment as well as QMEs and AMEs. We have offices in Orange County, we have offices in LA, we have offices in Riverside and Santa Ana.